Good evening, viewers. My name is MC Chaka. I'm here today, City Media, with Solicitor Beyebenwo, Thomas Beyebenwo. We are here today to discuss certain issues, certain things that will help people in the UK. We're here to discuss Domestic Abuse Act 2021, Non-Molestation Order, Occupational Orders, and the immigration rules. But before then, I would like to get some few background information about Thomas. Thomas has been doing this program for quite a long time, and this is my first time hosting it. Thomas has been a very good friend. We've been friends for about 20 years, and it feels really good and exciting to be in the same studio with a colleague, a friend, and to be hosting a program where he is my guest today. So first of all, I'd like to welcome Thomas to the program. Lawyer, you're welcome to the program.
Thank you.
Okay, how are you feeling this evening?
It's fantastic. It's always fantastic to be in this studio.
Oh, that's great. That's great. So, to start with, Thomas is one of the renowned solicitors in the UK for city law solicitors. He's been working very hard. He's helped a lot of Ghanaians, the Ghanaian community, the African community. They're all proud of him. He's done an amazing job. And if you've been following this program, this channel for quite a long time, you notice that he's been discussing a lot of issues that have been confronting people. And today we're going to talk about Domestic Abuse Act 2021. It's a very new act that has just been introduced. So Thomas, before we start, can you tell me a little bit about your firm, your company, and where you're located?
Thank you, viewers. It's always an opportunity and privilege to be in this studio, knowing very well that most of you are watching the program. This program is quite educative. I am Thomas Beyebenwo, as most of you already know me, a partner for City Law Solicitors. We have a couple of lawyers, and we are busy in Barking. We specialize in numerous areas of law. We specialize in employment law, immigration and nationality, and asylum. We also do personal injury and clinical negligence. We specialize in the family law in terms of divorce, matrimonial, and children's act. On that, we do some aspect of public law as well. We also specialize in commercial dispute and civil litigation. So we specialize in most areas of law, and we are always willing to assist clients who come our way. We will do our utmost best to ensure that they get the best outcome for whatever reason they came our way.
Okay, thank you very much, lawyer. So viewers, if you're looking for someone to help you with any of the areas that they specialize in, I'm sure you know where to go, especially when you are in the UK. Thank you very much, lawyer, for giving such a brief intro about your organization. So let's move on to our topic for this evening, Domestic Abuse Act 2021. When we talk about Domestic Abuse Act 2021, what behaviors are considered as part of the Abuse 2021?
Yes, thank you, MC Chaka. Yes, the Domestic Abuse Act 2021, as is quite clear from the year, only received royal assent on the 29th of April 2021, and some parts are operational, some parts are prospective, which means that it will be enrolled, or it will be rolled between 2021 and 2022. But especially Section 1, Section 2, and some other relevant sections have become operational. And this have significance to people's immigration status and those who also may want to apply for British passport for their younger children. So when we say that, when we say domestic abuse, the definition could be found in Section 1 of the Domestic Abuse Act. And it gives very clear, distinct definition of behavior that are considered to be abusive Firstly, for that behavior to be abusive, there have to be a connection between two people, and those two people should be 16 years or more. So there is a personal connection between those two people, and the behavior could be it could be psychological, emotional. The behavior could be coercive. It could be violent and threatening behavior. It could be sexual. So all these behaviors, and it could also be economic abuse, where people use their means of economic to impoverish other people. So the definition is quite clear, both physical, emotional, economic, and obviously sexual. Yes.
Okay, that's fine.
The starting point is the connection between the two people. And I must go further to say that when they say the connection, that connection means that if, for example, you are married to somebody, or if you had plans of getting married, so one connection is being married. The second one is if you have intention of getting married, then there is a connection. If you ever be in sexual relationship with that person, or if, for example, you were in civil partnership, or even if you had a relationship in the past and you are no longer together, there is still a connection under the Act. And there is also people who are categorized as relatives. So when we say relatives, we are looking at the nuclear family, which is in ascending and descending line. For example, stepmother, stepfather, for grandparents, people who are related to the children. If, for example, you have parental responsibility towards a child, that has a connection. So first there have to be a connection, and then once the connection is established, as I have enumerated, then the behavior along the lines of either coercive, threatening violence, or physical or sexual abuse, then that will be considered as a behavior which is domestic abuse.
Oh, lawyer, thank you very much for defining this, because the characteristics sometimes they are very confusing and people might not really know what domestic abuse is, but you've given us a very good explanation. Before we go on the one thing that you hinted before I ask you a question about that, you said there should be a connection, and you mentioned sort of intimacy or maybe living with somebody, it could be children. But what I want to say is, let's say if you are living in a house with someone, but then that person is just like a housemate or maybe a flatmate. There's no relationship apart from, let's say, having the person as a flatmate, and you abuse that person. Could that be classified as domestic abuse?
No. If you look at the definition under the Domestic Abuse Act 2021, those connections are set up clearly in the definition. So if you are living with somebody and you are not in sexual relationship, you are not related to the person as a relative. When we say relative, we are looking at the Family Law Act 1996, Section 63. Mm-hmm. So that will define the kind of relatives we are looking at. So if it's just a co-tenant and there is no sexual relationship, then obviously the Act will not cover such relationship, because there's a clear distinction between the relationships that are covered and those that are not.
Oh, thank you very much for clarifying this too. So in your session, you mentioned economic abuse. What is economic abuse?
Yes, I think obviously most of us are already familiar with domestic abuse, and in the past there have been a lot of legislations on it. But the fundamental difference under the Domestic Abuse Act in terms of the new definition is that of economic abuse. And that economic abuse is any behavior that adversely affects the other person's ability to either acquire or to use money or property, or where that affects the other person's ability to acquire goods and services. So for example, if you are in a relationship and maybe money is coming into the family pot, and then one person decides not to allow the other party to use it, and he used that one as a way of controlling that person, then that becomes economic abuse, because as I've just defined, it is your behavior. So people have to be very, very careful, because sometimes we might not even be aware that whatever we are doing is amounting to domestic abuse.
Yeah.
Because if your behavior adversely affects the other person's ability to acquire or to use money or to acquire property, or for example, to be able to acquire or use goods and services, then that will be considered as domestic abuse or economic abuse, which means that if for whatever reason you are even stopping the other person from going to work to make money, then that could also be considered as domestic abuse or economic abuse.
Oh, really?
So that is quite, yes. So that is how the Domestic Abuse Act has broadened that definition to the extent that you may not physically abuse someone, but by restricting the person's use of legitimate funds may amount to domestic abuse. So for example, if somebody, maybe you got married to somebody from Africa or anywhere, and then you probably see that, oh, if you go and work, maybe you may not get enough benefit, or if you go and work, we might not be able to, you might be able to be self-sufficient, so I don't want you to work. That will be economic abuse. Yes.
Oh, okay. Thank you very much. So if you're living with your partner, and for instance, if you're getting a lot of money and you don't want your partner to also work to make ends meet or to get money, and you say, oh, you have to take care of the children, and it's your responsibility as a woman to take care of the children whilst I do all the work and make the money. So could that be classified as domestic abuse if the woman really wants to work and you restrict the woman from working?
Yes, the point is that I think the Act clearly has that intention of punishment, because the point is that if you are living with your partner and then you are the only person working, and then the funds are available for the use of all the parties in the relationship, then obviously there will be no cause of alarm, or none of the parties will complain. But in a situation where, for example, one party is working, let's say where, for example, people are on universal credit, one of them may say that, oh, because I'm working, I don't want you to work, because if you work, maybe we might receive a reduction in our universal credit. Or one will say that I don't want you to work because if you work, maybe you might form a relationship outside the marriage, so I want you to stay at home. And of course, we are aware that some tribes, they might decide to keep the women at home against their will. So it's the other person's, if that act is against the other person's will. And the starting point is that if that act prevents the other person or adversely affects the other person's ability to acquire or to use money or to acquire property, then it becomes economic abuse.
Okay, understand, yes. Fully understand. Viewers, if you just tune in, we're here with lawyer Thomas Beyebenwo from City Law Solicitors. We're here discussing Domestic Abuse Act 2021, non-molestation, occupation order, and the immigration rules that comes with it. So lawyer, let me ask you this quickly. You know, when you talk about domestic abuse, and especially when children are involved, then it becomes, a very serious problem.
Yeah.
So according to the Act, in what ways can children experience domestic abuse under this Act?
Yes, it's quite dangerous, because obviously people may unwittingly display some behaviors or conducts that indirectly might affect the children. For example, I've already set up what the domestic abuse is. So if the children either hear or they see, or they are able to listen any of these acts, or they are able to suffer any of these acts, then those children are equally experiencing domestic abuse. So let's say, for example, the two parties, let's say there's a physical violence or threatening behavior where the father and the mother, or whether the stepfather or whoever it is, because I've already defined that there have to be a connection between the parties.
That's right.
So where there is a connection between the parties, for example, father or stepfather, or mother or stepmother, and then they are, for example, are fighting in the house and the children hear it or see it, the children themselves have not suffered physical abuse, but the fact that they have seen it or heard it, it becomes domestic abuse. So this is how children may experience domestic abuse.
Okay, I'm sure there could be a lot of emotional, trauma or psychological effect, even in relation to children experiencing this kind of abuse. So when you talk about children, which people are considered as children under the Act?
Yes, it's a bit confusing, and I have to take my time. When you look at the definition of the Act, Section 1 makes it clear that when there is a connection between two parties who are 16 years or more, so that is the starting point of the definition. But when it comes to definition of children under Section 3, it makes it clear that children are anybody who is either 18 years or below. So as long as that person is below 18 years, then whatever you are doing, that child should not see it, because if they see it, if, for example, your partner doesn't complain and that child complains, then there is going to be an issue. Okay. And I'm sure when we go through this discussion, we'll see some of the consequences for.
Okay, then. All right. So, children experiencing domestic abuse, what are the public law implications?
Yes, I'm sure that those who are familiar with, for example, social service or child protection officers, they are quite familiar with this. The public law implication is where the local authority, for example, finds out that their children are at risk of harm. So, and here I must give a caution. Sometimes people might just call the police just because they are having differences or problems in their relationship and allege that they have suffered violence. Now, if, for example, if anybody makes that complaint and there are children in the house, the public law implication is that, as I've already said, if the children are in the house and probably have witnessed that, it could be a lie. But the fact that you are saying that your husband or your boyfriend has beaten you up, maybe it might not even be true. But the fact that you are alleging that, then it means that those children in the house who might have seen it or heard it have suffered domestic abuse. So the public law implication is that the local authorities may seek to take those children away from those parents. So that is the public law implication. But obviously it's a very special area of law that we may go into it.
All right, so is it a way that maybe they'll take your children away from you and they become looked after children, they put them into foster care and stuff like that?
That sort of thing.
Oh, okay. So what are the implications or the consequences of being in breach of Domestic Abuse Act 2021?
Yes, if you are in breach of the Domestic Abuse Act, then obviously there are sanctions. People can receive custodial sentence up to about 5 years. So we are talking about very serious stuff here. Just because somebody has suffered economic abuse might land somebody in jail for about 5 years. So that is one of the consequences. The fundamental consequence is that you could go to jail for being in breach of the Domestic Abuse Act, and you could receive custodial sentence up to a maximum of about 5 years.
Okay, all right. So that's a very serious one. So viewers, we all have to be very careful, especially under this act. If you are in the UK, I'm not sure about Ghana, any other countries, but then it could be similar. But then if you are in the UK, the Domestic Abuse Act 2021, the consequences of breaching it could warrant 5 years imprisonment, which we all don't want to do that. So we have to be very careful and make sure we do the right thing to avoid domestic abuse. Thank you very much, lawyer. Today we are learning really, really good. So can you explain the difference between domestic abuse protection notice and domestic abuse protection order? These are very confusing terms. Is that the?
Yes.
Yeah. So what is the difference, please?
Yes. I must say that some of these are prospective under the legislative, which means that they have not become operational. But the difference between the domestic abuse protection notice and then the order, the notice is normally given. It's a notice that the police are empowered to give it to whoever they reasonably believe that have been involved in domestic abuse, where there is identified victim. So, for example, if you call the police that your girlfriend have slapped you, then of course when the police come to the premises, they are empowered under the Domestic Abuse Act to give a notice. So they can give a notice to ask you to leave the place, and then within that notice, they could also within 24 hours summon you to the magistrate court for that person to be tried. So that is the notice. Now, when it comes to the order, the difference is that the order is obviously, as the name implies, is given by the court. Yeah. So the family court will be empowered to also give domestic abuse protection order and then set conditions which the perpetrator may have to abide by.
Oh, great, yes. Great. So, obviously, we can't talk about domestic abuse without mentioning victims. And we know the local authorities will definitely have a duty to protect the victims. So what are the duties that they have, obviously, to protect the victims of domestic abuse?
Yes, victims. The local authority obviously have duties under the Act. And some of these duties, they've had it in the past and they've already been acting along those lines already. Now, the starting point is that if somebody have suffered domestic abuse under the Act, then the local authority have to provide a refuge. They also have a duty to provide accommodation. But within the Act, they have been empowered to the extent that if, for example, local authority, you are living in a accommodation which is provided by the local authority, and you are the tenant, you have the tenancy with the local authority, and then you have subjected your wife or your boyfriend, where there is a connection between the two of you, to domestic abuse, then the local authority has the power to evict you and then transfer the tenancy to the other person's, to the other person that is not named on the tenancy, or they could also provide alternative accommodation for the victim. So these are the duties of the local authority, and they have been empowered to the extent that they can obviously do certain things against the perpetrators, and it was providing sanctuary or refuge to the victims of domestic abuse.
Oh, that's good. Thank you very much, lawyer. All right, viewers, if you've just tuned in, my name is MC Chaka, and I'm here in the studio, City Media, with lawyer Thomas Beyebenwo from City Solicitors. We are today discussing domestic abuse at 2021, non-molestation, occupation order, and then the immigration rules that comes with it. So we're moving on to non-molestation order. I know this is a very big order, but we find it very confusing and some people don't really understand. When you talk about non-molestation order, what is the meaning of that?
Yes, the non-molestation order has been obviously under the Family Law Act, has been there for a long time. The Domestic Abuse Act, which we have just looked at, the protection order and the notice have just been introduced. So normally the non-molestation order, if there is obviously threatening behavior or abuse, verbal abuse or any of those acts, then one of the parties can also make an application to court under the Family Law Act and then get protection where an order will be made to stop the other person for engaging in certain abusive behaviors which will be enshrined in the order. So the family court will be able to make an order to say that you should not engage in certain acts or verbal abuse or through another person to abuse the victim.
Oh, okay. So that is non-molestation order. And when this order is imposed, and let's say the perpetrator breaches the order, what will be the possible consequences?
Yes, it also, some have penal notice, it also have criminal sanctions where the person can be prosecuted for being in breach of the non-molestation order. So it's very important that when an order is in place, people abide by it. Beginning of my career, I had a client who obviously there was non-molestation order in place, an occupation order. He was not meant to come to the former girlfriend's house. He came there, and then the police were called, and then he was arrested and then sentenced, received custodial sentence for I think about 12 months. So it is quite rare that if people breach it, there are dire consequences for that.
Well, thank you very much, lawyer. Because in my professional career, I've dealt with a lot of cases of offenders breaching non-molestation order. So I know the consequences of that, and it comes with extensive custodial element, as you first explained. Thank you. But then with the non-molestation order, how long can the order last for? Could it be 5 years or indefinite? I mean, how long can it last for?
It depends. Normally between 12 months, but obviously if the act is continuing, then whoever is suffering it can always go to court and then renew it.
Okay.
Yes.
All right. And can it be, or can there be a situation where, let's say, if the wife or the woman is the victim, and obviously the male, the perpetrator, as normally I think most of the cases are, if non-molestation order is imposed, and the woman, or maybe they settle the issue in a very amicable way or in a family settings, can they overturn the order from court?
Yes, normally when such orders are made, there is always, most times, there is that prospect for one to apply to court to vary the order. Yes, so it is something that people can do. They can apply to the court to vary it. But obviously, it's up to the other party to also, the court will listen to the both parties and decide whether the order should be varied or not.
Okay.
Yes.
All right, that's fine. Thank you. What about occupational order?
Yes, the occupation order is quite similar, but the difference here is that whilst people with non-molestation order might live in the same household, except that they will be prevented from engaging in certain abusive behavior, occupation order removes the party who is a perpetrator from the dwelling house. So if you are with your girlfriend or your boyfriend, or you are in a relationship with the other person, and then you subject that person to abuse, then obviously you could be removed from that property when that person makes application for occupation order. So the difference is, whilst one of them stop certain conducts, whilst you could still be in situ, the other one will remove you from occupation. So that's why they call it occupation order. So you'll be removed from the dwelling house.
Okay, so if I understood you clearly, if let's say you are living with your wife,
yes,
and you've got a mortgage whereby the mortgage is under your name as a male,
yeah,
and you've abused your partner, or there's been element of domestic violence, and you've been sanctioned, or this occupation order has been imposed,
yeah,
can they throw you out from your own mortgage and then leave the woman there?
Yes, they can. The fact is that as long as there is a relationship between the parties, especially when there are cases involved, then the court might make an order for the perpetrator to be removed. But normally, what the court will be looking at is the risk of harm to the victims and then the housing need of the other parties. So where there is a severe abuse, for example, physical abuse, then the risk of harm will outweigh the housing need of the other party. So the point is that if the risk of harm outweighs the housing need of the other party, then you will be removed. But if, for example, it is something that is a minor occurrence, then maybe they might impose non-molestation order and then take into account the housing need of the perpetrator, and you might say share the property. Where there is the risk of harm is higher, or is giving more weight than the housing need of the other party, then of course you will be. It doesn't matter whether you are the one who owns the house in your sole name. you could safely remove from occupation. Yes.
Wow. Viewers, let's take note of this. It's very serious topic that we're discussing today. Domestic Abuse Act 2021, non-molestation order, occupations order, and the immigration rules that underpins, so that comes with that. My name is MC Chaka. I'm here in the studio with Thomas Lawyer Beyebenwo. Lawyer has been a renowned solicitor for city law solicitors, and today we are here. Today is my first time interviewing lawyer. It's been very great, and I'm really enjoying the topic, and I hope you are doing as well. But then please make sure you share this for everyone watching, or everyone that you think might benefit from this. Please make sure you share it, because it's very important. Domestic abuse, the prevalence of domestic abuse in UK is getting overwhelming. So please share it. Subscribe it. We're here every Tuesday and then Thursday to discuss legal matters. I'm here with lawyer. We're going to go for a short commercial break. After that, we've got more questions, and then eventually we'll open the phone lines for you to ask questions. You can also drop your questions on the comment section, and then I'll read for lawyer to give you explanation. So please stay tuned. Don't go away. Please stay tuned. Don't go away. Viewers, welcome back. My name is MC Chaka. I'm here with lawyer Thomas Beyebenwo from City Law Solicitors. We're discussing Domestic Abuse 2021 Act, and then non-molestation, occupation order, and immigration rules. Welcome to the program. Please subscribe. We've shared quite very good ideas tonight. We've still got a couple of questions to ask lawyer. Lawyer, under what circumstances can one apply for non-molestation and occupation order? Can it come together at the same time?
Yes.
These two acts.
Yes, one can make application under both Section 33 and 42 of the Family Law Act. And depending, as I've said, depending on the circumstances, then the judge will decide whether you should give occupation order where the person is removed from occupation, or non-molestation order where the person perhaps stays in occupation, and then he's stopped from doing certain acts. So it is still possible for the two to be granted at the same time.
Oh, that's fine. All right. So now we know and we understand the non-molestation order. We know the occupational order. These are orders that can be applied in court. Anything here, order is applied through court. So if there are issues that you really want to, viewers, you would really want to apply for any of them, you know where to go. City law solicitors are there to help you. They deal with family laws, all kinds of law or legal practice. So if you approach them, I'll introduce them again. I'll give you the number. You can contact them anytime that you are confronted with any legal matters at all. We're going to move on to immigration. So how can people fleeing domestic abuse relationship protect their immigration status?
Yes, obviously it is normally those who are vulnerable that suffer the domestic abuse, people who feel that for one reason or the other they have to keep mute and they don't seem to have a voice because they are terrified that by speaking out, then they stand to lose certain things. Some of them, obviously, most important one would be people who have just migrated to this country, and obviously these days people can have a spouse visa that will be valid, that will be on the route for up to about 5 years. So which means that if, for example, you have a spouse visa and then you have to renew it every 30 months, and of course, if, for example, you are going through abuse, you might feel that, oh, by speaking out, the sponsor will not support your application. And because of that, people tend to keep quiet, and then they suffer in silence. And that is the main reason why this abuse, our Domestic Abuse Act, has been legislated. So it is quite significant that if anybody have suffered domestic abuse or economic abuse, as we have defined from the beginning of this discussion, then that person should not be perturbed if because of their immigration status, because the immigration will make provision for people who are fleeing domestic abuse to make application and to be considered as if the sponsor has provided documents. So it's a matter of those parties who are seeking to make that application to make it clear and provide evidence of domestic abuse in support of the application, and then they will not be required to provide supporting evidence from the sponsor, because in most cases it is their fear that that sponsor will not provide supporting documents to support the application. That is why they tend to suffer in silence. So obviously, if you are suffering abuse, then there is that exception or exemption where you may not have to meet the Appendix FM requirements under the spouse in terms of maintenance and all those stuff that people have to provide to support the application. So that is how people can protect their status. So if, for example, anybody is suffering domestic abuse, you need to act fast. Obviously, you need to have an evidence to show that you have suffered domestic abuse. And if you do, because in practice we have realized where people have not been able to renew their stay, and clearly you can sometimes see that there is domestic abuse, but they have no evidence to support the application, and the perpetrator might not also support the application. So sometimes it is significant that people seek advice in advance. They don't wait till their leave expire, because there is protection under the law for those who are suffering domestic abuse in terms of their immigration status.
Yeah, I mean, you've really hit the nail on the head, because I know, and obviously a lot of people are suffering in silence because they think, oh, it's my husband that brought me into this country, it's my husband that is doing this, so they keep quiet, they don't even voice out, because they know when maybe they are due to renew their status, the partner might not provide all the documentation. But from what you just said, if they obviously so if they are suffering and they've got evidence that obviously they are having or facing domestic abuse, they can still apply or legitimize or legalize or regularize their stay in this country. There's a loophole, there's a section that will allow that to obviously happen.
Yes.
And if obviously they come to you as a lawyer, would you be able to support them,
of course,
to make the application?
Yes.
Okay, that's good. So viewers, you know where to go. If you've been a victim of domestic abuse, it's something that we don't have to tolerate. It's something that we all need to voice out to make sure we come back to it, because a lot of women are suffering in silence. Lawyer, I've been saying women. Has there been any incidents where domestic or men have been rather the victims of domestic abuse?
Oh, of course.
Because you've defined the characteristics, which obviously encompasses emotional, economic, psychological, all the terms that you mentioned. sexual is even part of it. So, I mean, how do men report, or how do they go by, obviously, explaining or coming out with domestic abuse issues?
Yes, sadly, men, we are meant to be strong. And, we tend not to complain. Obviously, women are seen as quite weak. I must say that I have a lot of female friends who are quite strong, stronger than men. So the fact is that if men also suffer a lot of this abuse, because men, or some of them are also brought from Africa, and they also go through the same thing that women also go through. So if you ask me that, have I come across a man who have suffered abuse? Yes, I come across them in various areas of my practice, both immigration and under the family law. A lot of men, even because of the fact that they may feel that they may not have contact with their kids, if for whatever reason they are removed from the house. So men also suffer abuse. And that is why we are doing most of this program, to conscientize people so that people can be aware of their fundamental rights under the law. Because it is quite horrible for either a woman or a man to suffer such abuse. And it is against the law. So, but the truth is that men equally suffer abuse. But there are a lot of men who are suffering abuse in silence. Some either because they don't know their right with respect. Some is because we are told to be strong, and therefore by complaining about your relationship in terms of whether sexual abuse, psychological or economic abuse, you might be considered as being a weak man. Therefore men tend to keep quiet. But it is a fact that men also suffer domestic abuse.
Okay. All right, lawyer, well done. Thank you very much for this explanation. Moving on to my next question. Can parents rely on domestic abuse to apply for passport for their children?
Yes, this is a very special area. I think Thursday we'll have a special session on this, because there is a very new case which the Court of Appeal, the case of GA and ORS versus the Secretary of State, which has confirmed. And I will take my time this week, Thursday, to go through that case and educate people how they can apply for British passport for their children without the support of the sponsoring parents, based on this new case which has just been adjudged by the Court of Appeal. Now, when I say this, most of this stuff that we discuss here, it affects both men and women. Now, I know I have come across men who have had children with certain women who may, for one reason or the other, and I personally represented somebody who solely decided that they will not get a passport for the child, because if they get a passport for the child, the man will be able to use it to regularize his stay. And therefore they may decide not to get passport for the child. Now, if for whatever reason this man wants to make an application for the child, even though mothers under the law have automatic parental responsibility, when there is an abuse, domestic abuse, then that man may be able to apply for passport for the child without necessarily the support or the consent of that sponsoring parent. The same applies to women who have kids with men who, for one reason or the other, may decide, and again, I come across these cases all the time. Most times when we come here to do these programs, it is based on what people are suffering from, what people are going through, and then we organize the topics so that we can conscientize those people who are watching, so that they can know their right. Now, most times, lots of these women may have this case, no passport for them. The child is entitled to a passport, but the father may decide that he will not make that application for the child, because if he makes that application for the child, then the woman may be entitled to regularize his stay. Again, you can, based on this domestic abuse that we have discussed, you can make the application for passport for the child without that consent from that sponsoring parent. And people may find it strange, but whenever I come here to talk, I don't speak legal fiction, I speak facts. It's based on the case of GE and ORS, which is a very fresh case that the Court of Appeal have just adjudged in July 2021. And in fact, this even extends to people who have given birth abroad. There are children who are born British, automatic British, because one of the parents is a British, and the father or the mother may decide that they will not get a passport for the child for one reason or the other. So that's why I'm saying that this week, Thursday, I'm urging people to join us, because I'm going to take my time to even explain how somebody can get a passport for their child who is born here and sent abroad to either Ghana or Nigeria because they didn't have paper at the time. How that person can even register and bring that child into this country as a British. So there is more that I'm going to discuss on Thursday concerning how to get British passport for your child.
Okay, viewers. On Thursday is going to be the tree version with Diva Nova. Lawyer has just explained. He's going to explain into details how you can acquire passport for your children even in abroad. So please make sure you tell your friend, you tell everyone to subscribe and tune in on Thursday for the tree version. We'll be here every Tuesday and Thursday for legal matters. So if you just tuned in, my name is MC Chaka. I've been discussing Domestic Abuse Act 2021, Normalization, Occupation Orders and Immigration Rules with lawyer Thomas Beyebenwo from City Law Solicitors. Thomas is specialized in immigration law, employment law, family law, personal injury and clinical negligence, commercial disputes and civil litigations. He's one of the renowned solicitors that I've ever come across. If you have any issue at all, any immigration, any legal issue at all, make sure you contact City Law Solicitors. All right, so it's time to open the phone lines. The number is on the screen, so if you look at the bottom of the screen, you see the contact number there. But for the benefit of those who might not be able to see, I'm just going to read the number. It's 07932 934518. The number once again is 07932 934518. We've got our other number, which is if you call in from abroad, you can add the code, which is 0044, and it's 744 033 8623. Once again, it's 0044 744 033 8623. City Law Solicitors, Thomas Beyebenwo is my guest for tonight. The phone lines are open. You can call us and lawyer will give you an explanation. Not just the topic we've discussed today, but any other topic, any immigration topic or any areas that I have mentioned. Immigration, employment, family, personal injuries, clinical negligence, commercial dispute and civil litigations. All these areas, any question at all that you've got at this point, you can phone in and I'll answer and Thomas will give you explanation. So we wait for your calls. Please make sure you call. Thomas, whilst we're waiting for people to call, do you want to give a summary of what we have just discussed? Just for the benefit of those who have joined us now.
Thank you, everyone. Tonight has been very awesome. We had opportunity to discuss the brand new legislation, Domestic Abuse Act 2021. I must state here that parts of the act is prospective, which means that it's yet to become operational. There are some parts that are already operational in terms of the definition and all that. So we started by looking at conducts or behaviors that are considered as domestic abuse. And then we set out that for domestic abuse to occur, there has to be a connection between two people. And the legislation set out those personal connections. The connection has to be whether you are married to somebody, or you are in civil partnership, or you are cohabiting with a person, or you had the intention to marry and you didn't even marry, or you've been married and then you are divorced, or you have parental responsibility towards a child with the mother or the father, or you are a relative. And under the relative, we looked at which people qualify as relative. Under the Family Law Act Section 63, it says that relatives as her stepmother, stepfathers, in-laws, mother-in-law, father-in-law, those nuclear family, both in ascending and descending line. So we look at that one. We also look at fundamentally one of the elements of domestic abuse, which is economic abuse, where people engage in a behavior or that a behavior that affects adversely the other person's ability to acquire or to use money or property, or that adversely affect the other party from either acquiring or using goods and services. So, for example, if your behavior is preventing the other person from going out to work without any legitimate cause or reason, or it is a way of punishing the other person, then your behavior might be considered as domestic abuse. And then we also looked at which people, third parties that can also, who are not connected under the Act, but who might also suffer domestic abuse. We look at children under the age of 18, and we said that those parties can also experience domestic abuse if, for example, they hear, they see, or they listen to the violence or to whatever is happening in the house. So we have to be careful whatever we do in the house whilst children are around, because even if we don't get reported by our spouses or our partners, if the children go to school and they complain that father and mother engage in a brawl or in a fight or in a threatening violence, then that might cause problem for the household. So we look at that. We went further to look at the domestic abuse protection notice and then the domestic abuse protection order. Now, with the notice, we said that it's normally the police are empowered to give domestic abuse protection notice, which means that if police have reasonable belief to suspect that one have subjected the other party to domestic abuse under the Act, then the police can give protection notice. And that notice, within 24 hours, they can also take that person to court for trial under the Act for domestic abuse. Then we also look at the domestic abuse protection order, which is an order that the court might give. That order will state what that person can do and or cannot do. In fact, the order might even require the other person to give details if he's been a perpetrator of domestic abuse. Wherever he goes, he must have to give his details to the police or to the local authorities so that they will be aware that there is such a perpetrator, abuser living among us. So that can also be granted in the order. And then we went further to look at non-molestation order and then occupation order. We look at it under the Family Law Act, Section 33 and then 42, and then we set out conditions when people might be subjected to, or people might, an order against them could be made. And then we also set out how non-molestation order can be made against one by looking at the housing need of that person and the risk of harm to the victim. And it doesn't matter who owns the house in his sole name, that person can be removed if that order is so made. Those people whom the order has been made against them also have the right to apply to court to vary the order if the circumstances have changed. And then we went further, finally, to look at the immigration, which of course has, I'm sure Parliament have in mind when they made this legislation, because people who are suffering economic abuse, for example, they might not be able to speak out because they are terrified that if they speak out, they might not receive support to renew their immigration status. Again, we state that there is a protection under the immigration rules. While people have evidence that they have suffered domestic abuse, then they can make application without the support of the sponsor. We also look at obtaining a British passport for your child if there is a domestic abuse without the consent of the sponsoring parent. And again, we explained that under the Domestic Abuse Act, you could actually get a passport for your child without the consent of that sponsoring parent, who is begrudging you, denying you that right of getting you a passport for your child, and is using that as a means to abuse you. And we came to the position where I made it clear that Thursday is going to be very fantastic. On Thursday, I'll be looking at how you can get a British passport for your child. I'll go into detail. I'm going to even look at how you can get a British passport. For those of you who have children born in this country and then you send them abroad to Ghana, Nigeria, all over the place because you didn't have your stay then and now you have your stay, how you can bring those children back as British. I'm going to look at this on Thursday. I will be looking at it in tree. So I'm urging my Ghanaian friends and family members to watch us and then share our videos to their friends and family so that they can benefit from this immense advice that I always come here to give to the public free of charge.
The immense advice lawyer has been given to the public free of charge. In all honesty, if you go to any other lawyer, there will be a consultation fee that could amount to a very huge amount of money. But then this is us, we getting it free, and we say thank you very much, lawyer, for the good work that you did for the African community. You mean a lot to us. So the phone lines are still open. If you've got any question for lawyer, you can still contact us on the number below the screen. You can contact us. Let me acknowledge some of my renowned viewers. Samuel Gaza, Gennaro from Legon. Nice one, brothers. Peter Tokra watching you live. Mame Ajua Jumo, very educative, keep it up. Ofosu Hene Pajef, officer at what he does best, nice. Safo Kantanka, nice. Efia Wusua, informative. Nana Frema, thank for your help, lawyer. Nana Poku Efriye Patterson. Yes, that's my boy. Ra is watching live. Philomena Oche, very interesting and relevant topic. Mame Ajua Jomo is watching. God Santi, that's my brother in America. He says perfect. Watching you live from New York. Francis Kebi. I can't really understand this, but I think it might be some language. Bobo Kofi. I can't really understand. George Chum, Senior Manchaka. Thank you very much, my viewers. It's been a pleasure to obviously host this program with my friend Thomas Beyebenwo. He's a renowned solicitor, city law solicitors. He specializes in immigration law, employment law, family law, personal injury, clinical negligence, commercial disputes, civil litigations. It's been a pleasure to be with you all viewers. MC Chaka will be here next week, same time. But then, as lawyer said, on Thursday, it's going to be with Diva Blue. And that will be the tree version. You all need to lock it. From 8:30 with Diva Blue, you all need to lock it down. It's going to be tree version. He's going to explain how you can bring your children from abroad. You can help them obtain British passport. I mean, based on this Domestic Abuse Act. And there are so many things that lawyer is going to explore on Thursday. So please make sure you don't miss the Thursday show. And your host, MC Chaka, will be here next week. But then, until then, I say goodbye to my viewers, me, myself, and lawyer Thomas Beyebenwo. We say see you next week. And Thursday, lawyer will still be here. Thank you very much for watching. It's been a pleasure to have all of you watching this program.